Hello and welcome to this video on vicarious liability. So this is part of Tort Law. This video was aimed for A-level law students, and this particular video is just going to focus on the elements of vicarious liability and not justifications or criticisms. So first of all, we're going to look at what vicarious liability is and then explore the requirements for vicarious liability. So vicarious liability is quite kind of strange. It's not an individual tort, such as a claim for negligence or nuisance. Instead, it's a way of imposing liability for a tort onto somebody who didn't commit it. Now, originally, it was based on the idea that an employer has control over his employees at work and should therefore be responsible for any torts committed by the employee at work. But of course, this is not an easy sort of thing to prove now, and so it's quite complex. Now, what it means is the tortfeasor is still liable for the tort. It means they can also be sued, and they can pay damages through insurance, for example. The question is then, should an employer be responsible for the actions of an employee? You might consider if they're working at home, or if they're acting dangerously, and so on. So it is a bit complex. So for this, we need to look at the modern law. So the requirements then is, first of all, the claimant must suffer an injury or loss. We would then look at employer-employee relationship, how that's proven, and the connection between the tortious act and the relationship. So remember, vicarious liability, as I say, is not an individual tort, such as negligence, nuisance, or economic loss by way of negligent misstatement. But what it is, it poses liability for someone who didn't commit it, and usually the employer. And in terms of what you need to be looking at, it's usually going to be for negligent misstatement or a negligent act in your AQA Tort Law exam on paper 2. So the big question is, first big question is, are they an employee? Now, you're only going to be responsible as an employer for someone who is your employee. And so they usually fall into two categories. So employees, if you can be proven as such, would be the employer can still be vicariously liable. If they're not, they're classed as an independent contractor, and the employer will not be responsible. So the test will fail at this first stage. We have four broad tests. Now, the first two are the oldest tests and probably not in as much use, a little harder to prove now as well. But of course, we need to look at these as a sort of mental checklist. So we consider the control test first, and we'll explore that. We then look at the integration and organisation test, the multiple or economic reality test, and then the easiest one to prove really, this relationships akin to employment. So the control test is the oldest of the vicarious liability tests for testing employment status. And in Ewing and Noakes in 1880, the test was whether the master had the right to control what the servant did and the way in which it was done. And the justification then is if they're controlling to that degree, they should be responsible for what the employee does. Now, according to Judge McCarty in Performing Rights Society and Mitchell and Booker, the test concerns the nature and degree of detailed control. And then we go to development in short, and J.W. Henderson identified many key features which would show the master controlled the servant. This included the power to select, the right to control the method of working, the right to suspend and dismiss, and the payment of wages. Now, this is virtually impossible to apply accurately today, but there are circumstances which it is still useful in the case of borrowed workers. So if an employee in the situation seems to work for one person and is sent to another, then this is when you would use this test. And so a good case for this then is Mersey Docks and Harbour Board against Coggins and Griffiths in 1947. And this is where the crane driver was hired out by his employer as the Harbour Board to stevedores who loaded and unloaded ships. Now, by his negligence, the driver injured a person in the course of his work, and his employer, the Harbour Board, made a contract which set out he was an employee of Coggins, but Harbour Board had the power to sack him and pay his wages. Now, when deciding who was vicariously liable, the House of Lords decided the term in any hire of contract of an employee is not decisive, and the permanent employer is presumed liable unless the contrary can be proved. Now, if an employee alone is hired out, there can be inference that the hirer becomes the employer, but if the employee is hired out with equipment, as the case with the crane, the inference is not as strong, and the hirer may now have control over how the equipment can be used. In Hawley and Luminar Leisure, we have a bouncer who is supplied to nightclubs by a firm of specialist suppliers, assaulted a customer outside a defendant's club. The suppliers of the bouncers went into liquidation, so the injured claimant sued the club. Now, the court decided that as the club exercised so much control over the bouncer in how he should do his work, it was employed him and was vicariously liable. And via systems, a little complex, but just shows us that more than one employer can be liable at a time. If you're interested in reading the facts, of course, they're on the screen. So the control test usually only used then if somebody seems to work with one person and goes to work for another company. The integration is a little more modern, and what this asks us is his work fully integrated into the business? So if it's only an accessory to the business, the person's not an employee. So you might consider the difference between a journalist employed by a newspaper would be fully integrated compared to a columnist, somebody who just writes on an invoice basis when necessary, who will be an accessory to the business. More likely, you were going to use the multiple test or the relationship akin to employment test. So multiple test then is because the other two are problems, the court recognises a single test is not satisfactory and may produce confusing results. So this test considers various factors which may indicate employment or self-employment. And the test been updated so that all factors in a relationship need to be considered and weighed against their significance instead. So it's a toss-up between what factors make them look like an independent contractor, what make them look like an employee, and which is it they're more likely to be. So you've got things like control, is the employer in charge of the work? Is their personal performance, or is it capable of being delegated? In which case they're probably an independent contractor. And is there a mutuality of obligations? Do both parties need to do something in return for the other? Now the key case of this is ready mix concrete and the Minister of Pensions and National Insurance. Now the thing you need to notice here is it's about national insurance contributions. It wasn't a vicarious liability case, but it's useful to establishing whether somebody is an employee. Now, McKenna, in this case, Judge McKenna developed a test and set 3 conditions which need to be met before an employment relationship is identified. The first one is the employee agreed to provide work or skill in return for the wage. In most cases, this is going to be satisfied. Number 2 is the employee expressly or impliedly accepts the work will be subject to the control or some sort of degree of the control by the employer. And again, usually satisfied in your scenario questions. What we then need to do is consider all of the considerations in the contract, and they're consistent with there being a contract of employment rather than any other relationship. And so that last point then means that we need to balance factors which we spot in the scenario question. So if the worker is paid a salary, they're more likely to be an employee compared to if they're paid on commission or an invoice basis. If they're described as an employee in the contract, they're probably a contract versus not being described as an employee, sometimes as a worker rather than an employee. You might look at premises and equipment supplied. So, as a teacher, I'd be provided with a laptop, for example, or a computer, and I go to work. Whereas if I do another job, I might provide my own laptop or my own equipment. You might pay tax or national insurance as an employee if it's deducted at source, which means taken from your pay packet before you would ever receive it, versus paying tax as self-employed, which is more likely to make you an independent contractor. So there's no sort of shortcut here. You just need to find the factors. Which of those factors are more likely to make them an employee, which are more likely to make them an independent contractor, and sort of weigh them up according to their significance. These are just examples of relevant factors, not an exhaustive list. Good example of where this kind of test is used is Ferguson and Dawson, in which there was a contract which stated a building labourer was self-employed, but the court decided he was employed, and employers were required to protect him under safety laws. So of course not again vicarious liability case, but proving how employment status can be tested. The more modern test then comes from, sadly, some abuse cases. So these are relationships akin to employment. And what we've got is a set of situations whereby, like I said, abuse was the issue, but the test is that relationship is akin to or close to that between an employer and an employee, so it's fair to impose liability. So we call this quasi-employment. And one of the key tests you should look to then is the various claimants in the Catholic Welfare Society, in which the employer is more likely to have the means to compensate the victim and can be expected to insure against the liability. Now, the Act will be committed also as a result of the activity being taken by the employee on behalf of the employer. The employee's activity is likely to be part of the business of the employer, and the employer, by employing the employee to carry out the activity, will have created the risk of the act being committed by the employee. And finally, there is a greater or lesser degree of control by the employer over the employee. Now, I'm not going to read out the facts of the cases, but you can pause the screen if you want to. You can just have a check through the facts of the cases. I'll just go through them. Indeed, so you can go back over them and pause should you need to. So what we got is another case, similar time, 2012. This was E and the English Province of Our Lady Charity, and again the Court of Appeal stated the court was required to look for a relationship akin to employment, which was established by a connection between a putative defendant, which the person who has committed the tort, and an actor was sufficiently close so that it was fair to impose liability. And again, several questions needed to be answered. Was there control by the contractor over himself, organisation test, integration test, entrepreneur test? But we really need to stick to the Catholic Welfare Society test to establish this element. We also have the JGE and Trustees of Portsmouth Roman Catholic Diocesan Trust. And again, you can read the facts through this case by pausing. At this point, it might be a good idea to stop and consider why you would sue somebody for a crime. And the reason for this is, although not on the specification for AQA A-level law, is that torts are also crimes in some instances. So if you commit an assault, which is an offence against a person, or a non-fatal offence, that is also trespass against a person, which is a tort, which is why then there would be some liability for crimes. Now in this case, so Cox and Ministry of Justice was heard alongside another case in which somebody assaulted a customer at a petrol station. We'll come to that later. Is a prisoner dropped a sack of rice in this case on a catering manager in a prison. Now obviously the prisoner is not an employee in any true sense of the word, but in working in the kitchen, the question is, are they like an employee? Are they akin to employment? Now the relationship here then is one of other employment is in principle capable of giving rise to vicarious liability where harm is wrongfully done by an individual who carries on activities as an integral part of the business carried on by a defendant for its benefit. In this case, we don't have prisoners working in the kitchen, then the prisoners don't eat unless you of course get external providers, but usually that's the situation in prisons. Now, the Supreme Court recognised that today many workers may be part of a workforce without having a contract of employment, and in this case even prisoners, so this was akin to employment. We have Fletcher in Chancery Supplies. The claimant here was a police officer was riding his police issue mountain bike on a cycle lane alongside a busy main road. Now a man, T, suddenly emerged behind a stationary van, collided with the claimant in the cycle lane. The claimant fell to the floor and suffered severe leg injuries, and T had been working that morning, was wearing a work polo shirt, work boots, and told officers, I attempted to cross the road to where my shop is. He gave his shop as his home address, and the employer was vicariously liable. Now they applied the questions from Mohammed and Cox. The Court of Appeal decided that there was no explanation why he previously left the shop. There was no sufficient connection to his work and causing the accident to make them liable. So as we've got here, the Court of Appeal suggests there was no vicarious liability because they were not employed at the time, which will come to a slightly different point. A more modern case then is Barclays Bank and various claimants. Again, this was a GP examining prospective employees of the bank, and he committed alleged assault during these examinations, but he was held to be an independent contractor. This was clearly outsourced work. They were not employed by the bank. And a more modern case again, so we've got the Jehovah's Witness organisation and BXB. So this was an anonymous claimant, or in this case respondent to an appeal. Now you can see this using the address there if you want to. You can go to the Supreme Court website and watch this judgment. It's a very interesting and sort of informative video. But in this case, an elder committed sexual assault on one of the congregation, but they were also friends. And the question here is, Well, two questions. Was he an employee? And it was definitely akin to employment. Now, due to the structure of this organisation, being voted in to be an elder and so on, he was definitely had a relationship akin to employment. Now, the case sort of failed. There was no compensation due by the organisation, and that's because there was no close connection, which we can come to later on. Okay, so we've dealt with each of these tests to establish employment. What you need to think of these, as I said before, is as some sort of menu. Consider control, integration, multiple tests, relationship akin to employment. But the reality is, only the last two are going to be applied in your problem questions, though you would get credit if you were able to successfully apply the other two. Usually, there's not enough information for the first two, and so we need to look at the latter two to apply them. Now, by all means, list before application. List them all and then pick the one you think is most appropriate and run with that one. And of course, what we need to do next then is consider, once we've established the employment status, now they do need to be an employee or have quasi-employment. We then need to see, is there a connection between what they did, so the negligent act or omission or the negligent misstatement, and then the relationship between, are they doing it at the time, essentially. So the question is there a connection between the act and the relationship, or is the tort committed in the course of employment? So they're doing the job at the time. Now, for A-level law purposes, the tortious act, the tort is going to be either negligence, which causes physical damage, personal injury and or psychological harm, or of course negligent misstatement, which causes economic loss. Now, they're the two most likely. Of course, we're not going to have some crossover between crimes and torts, unless of course it is in isolation or a multi-choice question, or indeed if this forms part of a theory question on question 9. But in terms of scenario basis, we need to know it could be negligence, so somebody is driving a van and is employed by somebody, for example, or somebody is sent to give advice on a particular issue by their employer, and there is a negligent misstatement for which there is some economic loss. So in order for the employer to be liable, the employee has to commit the tort in the course of employment. Now, what is in the course of employment or not is a question for the fact for the court to determine in each case, or for you in your problem questions using case judgments in the past. Now, it's often difficult to see consistency in the judgments, and recent judgments appear to be weighted in favour of claimants who have been injured by the employee. However, in reality, what we do is use the close connection test. So, is the incident closely connected to the person's employment? Now, these have all been based on case law. What we've done though is found an example of, or rather examples of, where employers will be liable and where they will not be liable. So usually then, we go for an employee is doing his job but acting against orders if the employer is doing the job. So if they ignore the instructions from the employer but they still do something wrong, then the employer can still be liable, and we look to that in more detail. Or the bog standard, if the employee is doing his job negligently, so he's giving negligent advice or negligently doing an act. And of course we've got that last one, the criminal act of an employee, if there's a close connection between the crime and the work he's required to do. Now, an employee will not be liable then if the employee is on a frolic of his own, and we'll explore that one. For a tort which is committed outside of the scope of the employment, so something not connected to employment, or indeed, swinging right back for the tort of an independent contractor with a simple reason there will not be an employee. So the first one we're going to look at is for an employer who's doing his job, acts against orders. So if the employee is doing the job, the only way this normally doesn't work is for an unauthorised lift. Now, in Olympus and London General Omnibus, the employer instructed bus drivers not to race other drivers while collecting passengers. One driver caused an accident when racing, and the employer was liable to the injured claimant as the driver was doing what he was employed to do, even if he was against orders. Now, in Rose and Plenty, a dairy instructed milkmen not to use child helpers on their milk rounds. One milkman did use a boy to help him, but the boy was injured on the round due to the milkman's negligent driving of the electric milk float. The dairy was vicariously liable because the judge suggested the dairy was benefiting from the work done by the boy. Now, Twines and Beans Express tells us that if the employee gives an unauthorised lift to somebody, then the employer will not be liable because that's sort of outside the scope of the employment. In this case, the claimant's husband was killed through the negligence of a driver who had been forgiven to give lifts, and this instruction was supported by notices on the side of the van stating who could be carried in it. The employee was not liable as the driver was doing an unauthorised act and there was no benefit. Another case which involves lifts outside the course of the employment was Conway Wimpy. So an employee of a building company gave a lift from workers to another company around a large construction site on an aerodrome. There were notices on the lorries forbidding them to give lifts to workers from other companies, and employees were also verbally warned about this. And the claimant to work for another company was nevertheless offered a lift by one of the defendant company's employees and was injured getting out of the lorry due to the employee's negligence, and the company was unaware such lifts were being given that they gave instructions not to do so, and again the company was not liable because this was an unauthorised lift. So the next thing to consider is if he does his job negligently. Now this really in your exam is going to be the one you use most because it's going to be a negligent act or indeed negligent misstatement, so this would cover both circumstances. In Century Insurance, a good case to use, and the Northern Ireland Transport Board, this is where a petrol tank driver was delivering petrol to a petrol station when he lit a cigarette and threw a lit match into the ground. This caused an explosion which destroyed several cars and damaged some houses, and the employer was liable to pay compensation as the driver was doing his job, even though he was doing it negligently. So the final one, where the employer will be liable, is where he does a criminal act and there's a close connection between the crime and the work he's supposed to do. A good case is and the Chief Constable of Merseyside Police, in which 2 hours after he'd gone duty, the defendant was parked outside a nightclub still in uniform. Now, a first aider from the club was worried because a young woman was very drunk and had taken ecstasy, and he offered to take her to the police station, but instead he took her to his house, where he committed various sexual assaults, and including rape. The court here held that there was no close connection between the defendant's employment and the assaults. He merely made use of the uniform to gain trust and to abuse that trust. Now, Matters in Pollock was a bouncer in the case, was employed to keep order outside a nightclub. Now, the bouncer inflicted serious injuries and the customer was jailed for committing serious criminal offences. The nightclub here was held vicariously liable for the bouncer's actions, as he was encouraged to use force, to be violent and to be intimidating, and his criminal actions were closely connected to his work. Then we got similar cases, similar to the Catholic welfare cases, in which listed in Helsey Hall. If the employee commits a crime during his work, the employer may be liable to the victim of a crime if there's a close connection between the crime and what he was employed to do. This here was a warden of a school for children with emotional difficulties, and he sexually assaulted some of the children. He was convicted of criminal offences, and the House of Lords decided there was a close connection between what he did and the assaults, given that he only had access to the children as a result of his job. And this new test that was introduced by the House of Lords is close connection test. We've seen as well various claimants in Catholic Welfare Society where there was an enterprise risk in situations where the defendant is in a position to use the employee to further his business interests and done so in a way that created or significantly enhanced the risk, then they might establish a close connection. We also referred to Mohammed and Morrison supermarket earlier on, in that a man here assaulted a customer, causing him serious injuries, and the Supreme Court considered the job that he'd been given to do to the employee, whether there was sufficient connection between this job and what he did to the customer. They decided he was acting within the field of his employment because, of course, it's during working hours, and you might argue that there is going to be some sort of conflict between customers and workers in a customer service facing role, and this was just a little bit of a step beyond what was expected, and as a result the company was liable as well. Now, another case involving the same supermarket, Morrison's, was various claimants in 2020, in which the employee here made a copy of the claimant, so multiple claimants' private and confidential information held on, and he held on the payroll and uploaded it to the internet. And again, the test is here, was the crime closely connected to the employment? And because he had access to the data handling, it was held to be closely connected. So an employee then will not be liable if an employee is on the frolic of his own. So it's roughly referred to as on their own time, so something they're not paid to do. This might be driving to work, for example, in which it's your own time, but it might be different if you're driving from one place of employment to another. So Hilton and Thomas Burton in 1961, if the employee causes injury or damage to another while doing something, or at a time outside the area at the time of their work, they're not going to be liable. In this case was where the employees were working away from their workplace and took an unauthorised break by driving a firm's van to a cafe for tea, but had an accident on the way back, and one of the workmen was killed. His widow sued the employer, and they were not liable because there was a frolic of their own and not acting within the course of employment. But as outlined before, if they're driving from one place to another or they're still being paid, then the employer may still be liable. And in Smith and Stages, the employer was driving back to his place of work after working elsewhere and caused an accident. Now the employer was liable here because the court decided he was acting in the course of employment as he was being paid during his travelling time. Now we also need to consider then if the tortfeasor, the person who committed the torts, field of activities not associated with their actions, then the claim would fail. In this case was a Christmas party, a Christmas works event, but in fact what happened here was the defendant was drinking, picked up a claimant and dropped it, causing a serious back injury. And to summarise this particular case, we got the idea that it's a frolic of his own because he wasn't paid to dance, he was paid to be a scientist instead. And Isma Ali and Luton Borough Council here, and again a council employee leaks sensitive data, but the judge found a local authority could not be held responsible for someone acting in a frolic of their own. So similar but slightly different to the Morrison's case earlier. The next thing then to consider is the things outside the scope of employment. So if you're doing something which you're not paid to do, then the employer will not be liable vicariously. In Beard and London General Omnibus, again, this is the idea of outside the scope of employment. Now, bus conductor here employed to collect fares drove a bus without the authority of his employer, injuring the claimant, and the employer was not liable as the conductor was doing something outside of the course of his employment. And so as we discussed on the issues on the screen, there are certain situations which are developed through common law where the employer will be liable, and situations where the employer will not be liable. And again, just revisit each section to understand those. And that's the requirements. So one type of loss or injury, so negligence or a negligent misstatement. Of course, in an exam question, the first thing you do is apply that to the original defendant and then consider if there is an employer-employee relationship, and of course the relationship and the Torts Act, there is a close connection between what they did and their job. The final issue, and to summarise what you should do then, is of course you need to explain that the original defendant can be liable, but in some cases the point of this is that they might not be able to pay, might not have insurance and so on. So if a tort is committed by an employee acting in the course of employment, then the employer usually pays, and that's how you should summarise. But compensation can also be taken by virtue of the Civil Liberty Contribution Act of 1978. The employer can recover any compensation from the wages of the employee. So just list that at the end. But that's the end of this video. Thank you.